Well, hello and welcome. Thank you so much for agreeing to help us out with our judge for the students for the 2025-2026 season. We cannot do this without your help. And so we are grateful for all the time and energy that you're willing to dedicate to helping these students be the next generation of constitutional experts. This year's case packet is an exciting one because it deals with something that we are currently learning about in our court system, that's currently going through the court system, and that we may hear a decision on soon. In this video training, I'm going to be walking you through that packet, and I'll be telling you all about the details to help you be prepared so that you can ask the best questions and evaluate our competitors in the best light. Two preliminary notes before we begin. First of all, it's worth noting that all of this information is not over and against the packet. Our packet writer, Anthony Severin, has written an excellent packet, and it's available on the website for you. I would encourage everyone to read the packet. In fact, even prior to watching this video or after watching the video, the packet should be read. And it's important that any information that I say that would be, in the off chance that it is in contradiction with what happens in the packet is what is technically binding and not anything that's said on these training lectures. All of these lecture modules are in an attempt to help you be the best possible judge, but they shouldn't be used as a resource to use during rounds in terms of quoting anything that's said in any of these lectures. So that's the first preliminary note. We'd encourage you strongly to read the packet. The second preliminary note is this lecture will be geared toward people who have very little to no understanding of the packet, the legal landscape, U.S. government, etc. Please don't feel like we're talking down to you if you have a lot of experience in those areas. We want to make sure that everybody is on the same page. And so we're going to start at a pretty basic level. If you do have legal experience, thank you so much for helping us judge. We are grateful for you. These lectures will still be helpful for you insofar as it's good to get a refresher and even to see the particular facts that you may have forgotten about in however many years it's been since you last discussed these issues. So without further ado, let's get into our lecture. This first training module, as I mentioned, is on the packet. So I'm going to be walking you through this year's case packet. Give it 1 second to load. All right, should be sharing now. I'm going to walk you through the details of the 2025-2026 case packets and walking you through the two issues that present themselves this year. First of all, it's important that we recognize this case is very heavily a U.S. government case. Many years we'll deal with constitutional issues that are from the amendments, for example, freedom of speech, freedom of religion, Fourth Amendment, privacy rights, Eighth Amendment, cruel and unusual punishment, Fifth Amendment, self-incrimination. Those sorts of issues are most common in moot court packets. This year's packet still deals with the Constitution, but not in the way that you might expect, because this year we're dealing with issues of the government and the branches of power. As you might expect, those do show up in the Constitution. Those kinds of questions, in fact, we might say are more central to the Constitution than the Bill of Rights. That's what this year's case packet centers on. So let's begin with a very basic refresher, which you can just think about as U.S. government basics, retaking AP U.S. government. Our government in America is founded upon the Constitution, of which there are three main articles that deal with the three branches of government. You're familiar with the opening lines, "We the people of the United States." What you're less familiar with is probably those three articles that come after. In order, the three articles are the legislative branch, the executive branch, and then the judicial branch. And that was an intentional choice on the part of the founders. The founders intended for that first branch to predominate, the one that's creating the laws. The legislative branch was the first one with the most power. The executive branch is the one that's supposed to carry out or execute the laws. But it's important to even here to note that the executive branch isn't meant to just simply do the tasks that the legislative branch gives it, but often has wide discretion with how to carry out the tasks that have been given it by the legislative branch. Hence why we care so much about the president we elect. If the executive official was simply just a law enforcement officer, then we could just elect anybody we want. But the executive branch who carries out the tasks of the legislative often has wide discretion. That's Article 2. Article 3 concerns the judicial branch of government, which is the Supreme Court, which you are simulating in your round with the competitors. Article 3 is less of an issue that will come up, at least not directly. We'll hear more about Article 2, which is the executive branch and the president, and especially about its conflicts with Article 1, with the legislative branch. You should also be aware of the doctrine of the separation of powers and of checks and balances. These two doctrines are actually fairly self-explanatory, and even if you haven't heard them in a while or haven't heard them ever, you'll probably understand them fairly easily. The separation of powers doctrine argues that the legislative branch has legislative function. It is not supposed to be enacting the laws, and it's not supposed to be ruling on the laws. Similarly, the executive branch is not supposed to be creating the laws, and it's not supposed to be ruling on the laws. And the judicial branch is not supposed to create laws or carry them out. Those three branches of government are supposed to be separate, hence the term separation of powers. The second constitutional principle that's important to note is that each branch has checks and balances on each other. The founders, in their wisdom, decided to create a constitutional republic that was to prevent somebody from taking all the power to themselves and predominating over every other branch. So they enacted checks and balances so that the judicial branch can check the legislative and the executive branch. The executive branch can be checked by the legislative branch through impeachment. The executive branch checks the legislative branch and the judicial branch by being in charge of appointments, etc. All of these are meant to both be separate from each other, but also to check each other. And that's the discussion. That clash is what we're dealing with in this first question. So as you know, moot court is split into two questions. The first question has to do with the legislative and executive clash, and the second has to do with the judicial branch. But let's first get the facts straight, and it all has to do with the Federal Reserve. You may be familiar with the Federal Reserve, at least in name, which has been nicknamed the Fed. The Federal Reserve is the central banking system, the central financial decision maker, economic decision maker of the United States. Back in 1907, there was an economic crisis, which caused the Federal Reserve to be created through an act of Congress in 1913. After the Federal Reserve was created, they were then tasked with fulfilling America's economic policy, and we'll talk about that coming up. There are three parts to the Federal Reserve, but first we want to talk about the tasks that the Federal Reserve does. Here I'm highlighting three tasks, or maybe four, we'll see. The first task is to stabilize the economy. The Federal Reserve is in charge of making sure that there won't be crashes like the crash of 1907, or at least minimizing the damage that would happen from those economic crises. The Federal Reserve has been given a dual mandate. The legislative branch, which created the Federal Reserve, has given them two tasks: to keep stable prices, i.e., to keep inflation low, and to keep high employment, or to keep unemployment low. If you want to remember that in very easy terms, you just say keep inflation low, keep unemployment low. That's the Federal Reserve's dual mandate. How they carry that out is up to the Federal Reserve's discretion. The second task of the Federal Reserve is to conduct open market operations, which typically is just the Federal Reserve buying and selling securities or bonds. You can think, if you want a very basic understanding of this, that the Federal Reserve is almost buying stocks in each of these banks. So think about a local regional bank. If the Federal Reserve buys or sells securities, they're almost buying a stock of that bank. In other words, they will give that bank money, and then the bank will in turn give them the bonds or the security. That's a very loose way of thinking about it. But open market operations is where the Federal Reserve is influencing what happens at the local level to help banks stay afloat. And that also controls how fast inflation grows, because the more they lend money to banks, the more money that banks have, the higher inflation, but at least there's a lot more spending, and so there's lower employment. When they sell securities and they basically are giving back their stocks to the banks, at that point, the inflation rate then will go down because there's less money in the economy, but also unemployment might rise. These tasks, which the Federal Reserve does, is called open market operations. Number 3, the Federal Reserve is required to set requirements for banks. This is one of the more controversial parts of the Federal Reserve's job, and you'll see it featuring prominently in the case packet as stress capital buffers, or SCBs. The Federal Reserve wants to ensure that none of the banks that are operating are at risk of being completely insolvent in times of economic hardship. Because if so, everyone who has money in those banks will be completely devastated financially, and then that will cause a big economic problem. So the Federal Reserve wants to make sure every bank that is open is solvent and will be able to survive in times of recession. They set these requirements for banks, and if the banks fail to meet those requirements, they then penalize the banks. Not in a legal sense, but they penalize, for example, by restricting buybacks and dividends. There are 4 tasks that the Federal Reserve does, and that's that they also act as a bank for the federal government. It's worth noting that while the federal government is using the Federal Reserve as a bank, the Federal Reserve isn't making their revenue through taxes. So even though the Federal Reserve is acting as a bank for the federal government, their revenue is primarily through buying and selling securities, i.e. they're making their money outside of the normal governmental process. You could almost say that they're making their money independently of the typical government process. Let's talk about the 3 parts of the Federal Reserve. There are 3 to highlight here. First is the board, which makes decisions for the whole system. So when we think about the Federal Reserve, we're most often thinking about the board of the Federal Reserve, which I will talk about in a second. They make big decisions for the whole system. And then we've got the regional part, the regional banks. There are 12 regional banks of the Federal Reserve. They're located in all the large cities. So think about San Francisco, New York, Philadelphia, etc. These regional banks carry out the policies that the board sets in their region, and they almost act as different branches of the Federal Reserve. And finally, the FOMC, or the Open Market Committee of the Federal Reserve, decides interest rates and monetary policy. The way the FOMC works is that it's comprised of the 7 members of the Federal Reserve Board, plus 5 members of the regional Federal Reserve branches, and those rotate in and out. And that group of 12 people decides interest rates and monetary policy for the larger country. All right. What is the Federal Reserve Board? Because they're the subject of this year's packet. The Federal Reserve Board is comprised of, as I mentioned, 7 members, and each of those members serve 14-year terms. Those members are appointed by a president, such that every president will be able to appoint at least 1 member of the Federal Reserve every term. Those 14-year terms, as you can imagine, are quite long because that spans over 3 presidencies, 3.5 presidencies. That's because the Federal Reserve is designed to be long-term. Economic policies are not just a one and done. You come in, you make one good policy, and you leave. The Federal Reserve is meant to create long-term positive economic policies, and that's why we need those 14-year terms. So there are 7 members on this board, each appointed by the president in consultation, and I guess approved by the Senate. This is important. It was probably obvious, but if it wasn't obvious to you, that's totally okay. It is part of the executive branch. Almost all agencies that you can think of are going to be part of the executive branch. There is no such thing as an agency that is completely like its own branch, because there are only 3 branches of government. So the Federal Reserve is part of the executive branch, similar to the Department of Defense, the Department of Homeland Security, the Department of Health and Human Services, the Department of Education formerly. All of those are part of the executive branch. Same thing with the Federal Reserve. It's part of the executive branch, which makes sense. Congress created the Federal Reserve with a mandate to keep prices stable, i.e. keep inflation low, and keep employment stable, i.e. keep unemployment low. That task was given to the Federal Reserve for the Federal Reserve to carry it out, i.e. execute that law. That's why they're part of the executive branch. Now, I say that it's important to note that it's part of the executive branch because I told you at the beginning of this training that the first question in this moot packet is where the executive and the legislative branches clash. The Federal Reserve is part of the executive branch, and yet the thing that created them, the branch that created them was the legislative branch. Congress created the Federal Reserve Board, and we'll see how that clash comes to a head in a moment. So here's the story. You can imagine on the left is our President David Bronner in this fictional universe. President David Bronner has campaigned on a promise to overhaul financial regulation. But that puts the board chair, who is Chairman Mark Crosby, at risk, because Mark Crosby was part of the previous administration and Bronner wants to remove Crosby. Now, at this time, around this time when Bronner is running for election, Fairfax Bank, one of the largest banks in the country, suffers severe economic distress, and the economy therefore suffers. With all of this downturn in the economy, the president wants to overhaul what's happening, and so he wants to take control of the Federal Reserve. And therefore, he says to Crosby, Chair Crosby, you're fired. Now, it's important to note why he fires Chair Crosby, because Crosby is not fired because Crosby has done anything wrong. In fact, it's made explicit in the packet that the reason why Bronner fires Crosby is because he wants to work with somebody of his own choosing. He has an administrative goal, and he wants to effectuate that administrative goal through his own people. And that's why he fires Chair Crosby. As you can imagine, Chair Crosby doesn't want to be fired. Chair Crosby doesn't believe that he should be fired. And that's because in the law that Congress made, creating the Federal Reserve, they created protections for Crosby. And that is the subject of question 1. These protections you can think about as removal protections. In Title 12 of the U.S. Code, Section 241 and 242, it writes that Federal Reserve members, including Crosby, cannot be removed except for cause. It's inappropriate, therefore, under this law for President Bronner to remove Crosby unless he has cause. And Bronner doesn't try to assert that he does have cause. He simply tries to say Congress has overstepped its boundaries by implementing these removal protections. Now, I've put removal protections in very large print because I need you to remember this phrase, removal protections. It's protecting Crosby from being removed by Bronner. And that's important because the question is whether these removal protections are constitutional. Congress writes these provisions into the law to prevent Crosby from being fired. But the question is this an unfair abridgment of the president's power to control the executive branch? And that's why we get question 1. May the president fire the Federal Reserve Chair without cause? Or in technical language, does the removal protection clause infringe on the president's power given in Article 2? Okay, so if you're following along a little bit slower, maybe you don't have a legal background, we need to break down this question. Remember that Article 2 is the second part that establishes the executive branch, that says all executive power shall be vested in a president of the United States. Now, if the Federal Reserve is part of the executive branch under the president's administration, and Congress says that he can't remove the head of that administration, the question is that removal protection clause constitutional? Or does it infringe on the president's natural executive powers that are given in Article 2? Let's talk about some arguments why that removal protection clause may be unconstitutional, why the president may be able to fire Crosby. So we'll start with what's the petitioner argument. So the lower court sides against the president, so the president is now the petitioner before you, the Supreme Court. You can remember it most easily by thinking P equals P, petitioner equals president. So if the petitioner is speaking, they're defending the president on both issues, the president on issue 1 and the president on issue 2. So the petitioner argument in this year's case, which is trying to defend the president, is trying to say that the removal protection clause is unconstitutional. Why would that be? Number 1, you think about the president as the CEO of the executive branch. He's the leader of the executive branch. Everyone who is working under him is working at will. And this isn't a controversial take. This argument itself is not controversial in any respect. Because of course, every person who's working under the president serves at the whim of the president. At least the default position is that you serve at the whim of the person above you. Nobody can claim that, when they get fired from their job, that they didn't deserve to be fired. They can argue that, but unless there's some sort of removal protection provision, we assume as the default that the CEO can fire those below him. Here, the president is the CEO of the executive branch. He's the head of the executive branch. So he should be able to determine who works with him. Especially if you think about it, the president, most of his duties is working with the cabinet to get things done in the economy and in American policy, domestic and international policy. He can't do that if he's not working with people with whom he agrees. And that's why it makes sense to say the default should be that the president can control the executive branch. The second argument is a combination. I'm using two big words or big phrases here, originalism and then unitary executive theory. I'll explain it again for the lay person who has no idea what this means. Originalism is a theory of constitutional interpretation, which says that we should interpret the Constitution according to the way that the framers of our Constitution intended for it to be interpreted. That's in contrast with living constitutionalism. Living constitutionalism argues that you should interpret the Constitution as in the way that we think is proper to interpret the Constitution, regardless of what the framers had intended. Why would originalism be a fair argument? Well, the petitioner would argue that what we've signed on to, what we've written, what we have put in contract in our law is the Constitution as meant by the framers. So to give an applicable example, let's say that your dad says that he wants to, let's say that there's a father in the family and he says, we're not spending enough time as a family. Let's all agree as a family to have fun. And your dad's idea of having fun is watching movies and playing board games. For a while, you all sign on to this contract and you all agree that you're going to watch movies and play board games. Let's say in this tragic universe that this father passes away and only the mother is in charge now. And she holds up that contract and says, you've signed on to we all agree to have fun on Saturdays as a family. And now she says, my idea of fun is gardening. So therefore we all have to garden. It's a funny example, but the point is that would be ridiculous to the people who signed on to it because they would say, that's not what I signed on to. We can't just reinterpret the understanding to which I've signed on to. Why I say all of this is, in terms of this case, the way that the founders envisioned the executive branch was not to think of three branches of the government plus the Federal Reserve, plus other government agencies, the three branches of government plus the Department of Health and Human Services. Indeed, the way that the founders conceptualized our government was only in three parts: the legislative, the executive, and the judicial. And that's why it's also called unitary executive theory, which is that there is no such thing as being an agency separated from the executive. The Federal Reserve is part of the executive branch. And how can he be the chief executive if he can't even control his own branch? Because one of the arguments you will see, and I'll explain it in a minute, from the other side is going to be, well, yes, the Federal Reserve is in the executive branch, but it's really an independent agency. It's not really supposed to be controlled by the president. But here the argument is, but the president should be able to control. You can't just create a whole fourth branch. You can't say that the Federal Reserve is just its own branch of government. And that would be this second argument here. The third argument would be that the Federal Reserve is needed, that the Federal Reserve serves a core executive function and therefore is an essential part of the executive branch. You can't separate the president from the economic policies that result from his administration. In fact, we intuitively know that. When inflation is high, we blame the president. When unemployment is low, we blame the president. Presidential debates, we talk about unemployment being low. How do you respond to that? The way that the petitioner says is, the argument that the petitioner makes is, how can the president be responsible for the economic decisions and yet not be able to control the Federal Reserve? Those two things are at odds. The Federal Reserve is a core part of the president's mission, and especially President Bronner's mission, and therefore he should be able to control his own branch. Let's move on to the respondent argument. So we said P equals P. The petitioner is the president. What would the respondents who are defending Chair Crosby and the Federal Reserve say? Three arguments I could think of. The first one is that the Federal Reserve is independent. So we just argued how under originalism, there are only three branches of government: the legislative, the executive, and the judicial. Well, one of the arguments that somebody could make, though, is, yes, it's technically true, the Federal Reserve, obviously, it's technically part of the executive branch. Nobody's arguing with that. But the Federal Reserve is not supposed to be political in the same way that the rest of the executive branch's functions are. In fact, it's supposed to be insulated from pressure. Can you imagine if we made the president just completely the president, not an economist in charge of setting monetary policy? There's a reason why we don't do that. And it's because we know that the Federal Reserve should be insulated from pressure in order to promote the best monetary policy. Federal Reserve might be ruined, we would say on the respondent, if we allowed the president to control all of the economic policies. They would prioritize short-term benefits over long-term gains. The second argument that the respondent could make is that the Federal Reserve is not fully executive. The Federal Reserve isn't really only doing executive functions. It's also kind of leaning into the judicial and the legislative branches. The reason why, by the way, this is different from the first argument is the first argument isn't trying to say that the Federal Reserve is legislative or judicial. They're trying to say it's within the executive, but de facto, like in fact, it seems much more disassociated with the executive branch. The second argument is trying to suggest that the Federal Reserve almost acts as if it is part of the legislative or the judicial branch at times. You might hear the competitors, the students, say quasi-judicial or quasi-legislative. That would be the argument for the second argument. So I gave three examples here from three different Supreme Court cases. And if you're interested in learning more about these cases, you can check out the next judge training video, which is about the case law. The first one is the Federal Trade Commission, which is in charge of breaking up monopolies, antitrust laws. In that case, which is called Humphrey's Executor, the Supreme Court decided that because the FTC performed legislative functions and performed judicial functions, they aren't really executive, and therefore the president can't be the only one to control them. The president actually can't control them because they're doing other functions. The same thing was true in the case of Weiner versus United States with the War Claims Commission in the wake of World War II. That commission acted quasi-judicially, as in it acted as a judicial body taking on tasks that a district court or a court of claims would take on. Because it acted as a quasi-judicial branch, they couldn't be controlled by the president because they're really not in the executive branch, even though they're technically an executive agency. Number three is the case of Morrison versus Olson, in which there was an independent special counsel named Alexia Morrison, who was in the executive branch, but investigating people in that branch. And the Supreme Court concluded, logically enough, that you can't investigate independently if you're controllable by the person who you're investigating. Imagine if Alexia Morrison were trying to investigate Ronald Reagan, the president at the time, but Reagan could tell the attorney general to fire her. Then she would be afraid to do her job. How can she do her job if the president can control her? Similarly, we might argue the Federal Reserve is not fully executive. They do some judicial things. They make decisions about banks and whether the banks are solvent or not. They do some legislative things in the sense that they create monetary policy. They set levels that banks need to be at, etc. They fulfill the dual mandate. And that means that they're not fully executive and the president should not be able to control them. Third argument here is that the Federal Reserve is not central part of the president. Yes, it's true that the president does have a lot of impact on monetary policy. We talked about this. But the president has many more ways to impact monetary policy than just the Federal Reserve. I mean, as you can imagine, tariff policies, tax policies, business policies, trade policies, all of those policies affect the economy in much larger proportions than just affecting the federal funds rate or just affecting the interest rates at which you're loaning to banks, etc. So while the Federal Reserve is important, the president can effectuate that policy without the Federal Reserve, and therefore he doesn't need to control the Federal Reserve. These arguments probably sound to you to all be convincing, and that's what you will be parsing through when you hear the mooters make arguments to you. I want you to ask them these questions, pitch to them these arguments, and ask them what they think about those arguments to see how well they can grapple with the material. So as review, before we move on to that second issue, Fairfax Bank had an economic downturn and the economy was in shambles. President Bronner then fired Chair Crosby without cause. And the question was, is the thing that protects Chair Crosby, the removal protections, are those an infringement on the president's Article 2 powers to control the executive branch? All right, feel free to take a pause here, review anything that you need to, and then we'll move on to Section 2. Section 2 discusses a separate issue, and this is going to be the second speaker's job. So we know that the president and Crosby both got into a little bit of a tiff where the president fired Crosby. Crosby has now been fired. But Crosby, of course, contests this. So even though Crosby has been thrown out of the game and been ejected from his seat, Crosby takes this to the district courts. Let me show you a brief graph of what the district courts are like. So think about this is the right slide. Think about the court system in a three-tiered system. So at the top is SCOTUS, the Supreme Court of the United States, which is the highest court of the land. It only accepts a small amount of appeals each year. Right below are the circuit courts, 12 courts plus the DC Circuit Court. And all of these courts are regional courts that hear appeals from the lower courts, and the lower courts are the district courts. Almost every case begins at the district courts. When you appeal it, you go to the circuit courts. When you appeal that, you go to the Supreme Court. In this case, it started at the federal district court, went to the DC Circuit Court, and now you, as the Supreme Court, are hearing this case. So at the district court level, Crosby asked the district court to tell the president that he's not allowed to fire Crosby because Crosby wants his position. He wants to be able to affect the economy. And the district court declares to the president, you are not allowed to fire. Now, that first issue, which we just discussed, is going to be discussing whether the district court was right or wrong to say this. But the second question is a kind of what if, or assuming if. In Latin, arguendo, for the sake of argument. Let's just assume, for the sake of argument, that the president is wrong. What should the district court then do? Because if the president is wrong, and Crosby should not have been fired, what is supposed to happen to Crosby? Now, you might say, well, logically, we should just put Crosby back in his position. The problem is, as we'll see, there are a lot of constitutional questions that you have to work around in order to put Crosby back in a seat. At this point, when we know that the president is wrong, the district court has, as Neo had, two options: to either give money to Chair Crosby or to put him back in a seat. So you've got on the left side, you could reinstate him, put him back in a seat. On the right side, you have the option to give him what's called back pay or compensation. He's been fired for unjust cause. The president needs to give him back that money. So for the entire coming year, he would be making $250,600, and he will receive that salary even without working as compensation for being wrongly fired. That sounds like a nice prize to me, to not have to work and get $250,000 a year. I wish that were true of me. So the district court decides, as you probably thought, to just put him back in a seat, because what's wrong? Just put him back in a seat. So they give the seat back to Crosby, and Crosby then or at least they declare that the president is not allowed to fire Crosby. They issue what's called an injunction to tell the president you can't fire Crosby, and Crosby is then technically back in his seat. So the question in very basic terms is, can the president remove The question one, which we just discussed, was, can the president remove Crosby? Question two then is if. Remember I said this is an assuming if. If the president cannot fire Crosby, a member of the Federal Reserve Board, without cause, did the trial court err in enjoining Chair Crosby's dismissal? Did they make a mistake when they enjoined Chair Crosby's dismissal? And you say, what on earth does enjoined mean? If you are not familiar with the legal language, you would have no idea what enjoined means. Under question what is question? Yeah. This is the basic, the more like low I guess, more accessible version of question 2. Should the district court have reinstated or just compensated him for being wrongly fired? That's the laid back version of this second question. So first we need to understand, what does enjoin mean? Because if you don't know what enjoin means, then you're going to be kind of lost with this question. Enjoin, according to Google, is instructing or urging somebody to do something or to not do something. In law, it's to prohibit somebody from performing a particular action by issuing an injunction. So when the president is enjoined from doing something, he's told not to fire Chair Crosby. So let's read this again, understanding now that enjoining means telling him not to do something. If the president cannot fire Chair Crosby, a member of the Federal Reserve Board, without cause, did the trial or district court make a mistake when they told the president to not dismiss Crosby, when they enjoined Chair Crosby's dismissal? Well, let's talk about the arguments. Again, P equals P, the petitioner equals the president. He's defending the president. Here's what P would say. Petitioner would say, first of all, courts have never historically mandated the president to do something. The court does not have the enforcement to be able to do so. In fact, throughout our history, we don't have any cases, at least that I'm aware of, where the president has been told by the courts that they have to do an action, except with one exception, which was like comply with a subpoena. But that's a completely separate issue, because a subpoena was like a court ordered him to like turn over documents and he didn't want to turn them over. And the Supreme Court said, no, you have to turn over the documents. That makes more sense. But we've never mandated the president to like put somebody back in his chair, where in this case, the court has to tell President Bronner, hey, president, put him back in his chair. To which the president might say, or else what? That's why I've got that sentence, the court lacks enforcement. Because what is the court supposed to do if the president says no? So imagine the court issues an injunction. They say, you're not allowed to fire Chair Crosby. And the president's just like, okay, cool, I heard you. But that's not going to do anything, because the president might, continue to revoke President Crosby or Chair Crosby's security clearance. He might even appoint somebody else new. The court lacks the enforcement to be able to make the president comply with their wishes. So that might be one of the reasons why they shouldn't just tell Crosby to go back in his seat, because they're not even able to enforce it. They're not the executive branch. They're only the judicial branch. The second argument is that injunctions do not typically include reinstatement. Here's a fact that you do need to know if you're hearing this case. Our court powers are derived from, not identical, but derived from the court powers in England. Because remember, we come to America and we want to have a legal system that is a successful legal system. So we mirror very strongly what happened in England. And in England, never did in England a court issue an injunction that effectively put somebody back in their position. And there were opportunities for courts in England to do so. There's this case called In Re Sawyer, which we will talk about in our case law lecture. And in that case, the president mandated, In Re Sawyer, the mayor was told that he could not fire the police chief. And the Supreme Court said, no, you cannot tell the mayor what to do about firing and not firing. And In Re Sawyer examined English law, British law, and they determined that there were multiple opportunities for British courts to reinstate somebody as a result of like a wrongful election or something like that. And never, ever was somebody put back in their seat. And it's not just like they didn't think about it. Like they just declined to do so because they don't have the power to, because they recognize that that's not the court's power. They only provided compensation. So if you lost the election unfairly, we give you extra money, but we don't reinstate you because that's not really the power that we have. So that's number two. There's not historically a precedent that we can issue an injunction to reinstate an officer. Number three is the doctrine that I introduced a few moments ago, the separation of powers. Remember that each of those branches is separate. Courts are not supposed to tell the president what to do, because what should the president be doing? What his executive duty is. He's the top dog. He's the CEO. How can somebody tell the president what to do? What happens if a president does something wrong? He gets him impeached. That's in the Constitution. But it doesn't say in the Constitution, if the president doesn't follow what Congress told him to do, the courts tell him to do it. If he doesn't do his duty, he gets impeached. Courts are supposed to be separate from the president so as to not tell him how to run the country. Otherwise, the courts would be effectively able to run the country, and that would politicize the courts more because they could then tell the president, hey, you've got to do this. You've got to XYZ. So in sum total, the petitioner defending the president is trying to argue that we can't tell the president to do something. And it's not that I don't want Crosby to go back in his seat, although I guess the president doesn't. But it's not just because of some personal bias. We don't have the constitutional or historical authority to put somebody back in their seat. We don't own in the executive branch. We don't own enforcement. We don't own the carrying out of laws. Only the president does. So what we can give is money. We can say, you know, the president has to pay damages. His office has to pay damages. We can issue a writ to make the president pay damages, but we can't tell him to put somebody back in their seat, because putting somebody back in their seat is a job only for the executive branch. As the packet says it, and if you read the packet, you'll see this, a balance is to make things right by paying him so that he's financially whole. Crosby gets all the money that he would have gotten, but allowing the executive to still be the executive and take control of the executive branch. Now you say that that sounds a little bit suspicious, because we said, if you were catching it, we assumed for the sake of argument that the president was wrong, that he couldn't fire Crosby. Hence, this next set of arguments. Number one, we're not telling the president what to do, like how to run the country. We're not telling him to, you know, here's how you should do deportation policies. Here's how you should do trade policies. Here's how you should run, you know, health and human services. No, we're telling him that he has to do something that Congress told him to do. Remember that the removal protections come from Congress. They wrote a law that said you cannot fire the chair without cause. The president disobeyed that law. That means that the president violated what Congress had told him to do. Now, there's a core constitutional principle, which is that you can never tell the president or anybody how to do their job. That's called a discretionary duty. You can never tell him how to do the duties which he has discretion to do. But you could tell him how to perform ministerial duties. What is a ministerial duty? Well, think about the word prime minister. A ministerial duty doesn't mean, as we might think if you are a church attender, you know, what a minister, a pastor, a priest has to do. Ministerial duty is what you have to do as the head of this, as part of your job. The prime minister is the person who has official duties. So the ministerial duty is saying, I'm telling the president to do what the law says. I'm telling the president to do his ministerial job. He has a duty to obey the law from Congress. That's a ministerial duty that the president must do. By the way, if that sounds extremely compelling and you're wondering how the petitioner can even squirm out of it, let me just give you a quick pushback so that you can re-understand why the petitioner might have some strong points here. The president has actually never been told to do a ministerial duty, even though conceptually we might say ministerial duty. I mean, we should be able to tell the president to do his job. We've never done it. We've only issued those ministerial mandamuses, writs of mandamus, excuse me, against lower officials. So we've only told people what to do if they're lower officials. Supreme Court has never told the president that he has to do something to like fulfill his official duties. So that's what the petitioner would say. Number two is that a mandamus is appropriate. So this word mandamus is brand new to some of you. You've heard injunction. We just talked about injunctions. What's the difference between a mandamus and an injunction? Injunction says don't do it. Mandamus says do it. So injunction, so let me just go back to this last slide. Remember how I said in number two, injunctions do not allow for reinstatement. Well, a writ of mandamus could actually. So you could argue a mandamus is appropriate even though an injunction is not. If you did that, though, you'd have to argue that even though we have no historical precedent for issuing a mandamus to the president, we can still do so. So again, to recap, injunction, don't do it, don't fire him. Mandamus, put him back in his chair. First, you'd have to say that putting him back in his chair is a ministerial duty. Like, it's his job as president. It's part of his duties as president, which I'm already a little bit skeptical about, that it's his duty as president to put him back. But second of all, you'd have to argue that you can issue a mandamus against the president, which we have no precedent of doing. Okay, so that's number two. You could argue for mandamus. The respondent could argue for mandamus, and that would be appropriate. Number 3 is where there is a right, there is a remedy. That's a famous quote from Marbury versus Madison, where the court says, if you've been deprived of something, the purpose of the courts is to give you something in return. Now, if the petitioner says money is going to satisfy, the answer is that it simply doesn't. Think about Crosby. He has the opportunity to not work for a whole year, to get $250,600 and not work for a whole year. Why does he say no? I've got to imagine that the reason he says no is because he cares about his job. He cares about the economy. He cares about doing his job well so that the American economy stays afloat. There's something to putting him back in his chair that would make him whole, and giving him back pay does not make him whole. And if Marbury versus Madison is right, that if you've been stripped of a right, you should get that remedy. If you've been stripped of his chair, he should get that chair back. That seems to be a fundamental principle of our jurisprudence. And there are, and we'll go over this in the case law session, there are a few cases that indicate that you could issue a mandamus, and even cases that indicate that you could issue an injunction. In fact, I would say that it's more likely that you can issue an injunction than a mandamus against the president. But in any event, there are cases that indicate that you can issue a mandamus against the president. They're few and far between. They may not be binding on the court, but they are existing. So on the respondent, you would say, if we need to make Crosby whole, and if it's even possible for us to make this argument in front of the Supreme Court, that the Supreme Court should put Crosby back in his seat because the president can be enjoined to do something, there can be a mandamus against the president, well, then we should make Crosby whole and put him back in his seat. All right, that's it for this presentation. At Root, I want you to think about one more thing before I end this presentation. I want you to think about one final thing, which is don't ever think about these cases as being completely one-sided. Our packet writer, Anthony, and the rest of his team have thought through many different iterations of the arguments. There is no one side who is just unequivocally correct. And if you think that there is, it's probably because you haven't seen all of the case law. Because I've read all of the case law front to back, and there's no absolutely right answer where the other side is just completely wrong. So if you find yourself leaning to one side or the other, I'd encourage you to watch this next training module on particular cases so that you can learn about maybe if a case could persuade you in a different direction, because both of these cases are meant to be fairly balanced so that both sides have an opportunity to argue for something that can sound good. Thanks so much for your attention here, and I hope that this lecture was helpful. If you have any follow-up questions, we are happy to answer these questions via email. If you'll reach out at contact@hsmca.org, you can find our website at hsmca.org. You can contact us through that email, and we're happy to respond to your questions. And then you can watch that next lecture, which I'd highly encourage you to watch on case law. I'll see you there.